A very warm welcome to all the participants joining us today for day 7 of the 6th Virtual International Summer School on Mediation, organized by Nothern in collaboration with the Commonwealth Lawyers Association, popularly known as CLA, and Singapore International Mediation Center, SIMC. Most of us are already aware of Nothern, its objectives, goals, and its mission. But for participants joining us for the first time today, it is my privilege to tell you Nothern is a group of Supreme Court accredited mediators working to enhance the reach and effectiveness of mediation. By fostering dialogue, training, and awareness, Nothern works to make mediation more accessible, structured, and impactful across the country. I am Mandakini Sharma, advocate and a mediator. It has been a privilege for me to be a part of Nothern, and I'm delighted to host today's session. The world of mediation has been an incredibly rewarding and enriching journey for me, and I'm enjoying every step of it. I must say I already feel deeply evolved thanks to the thought-provoking lectures and meaningful interactions we have had during this summer school, and today is going to be no different. Today's topic covers the very essence of mediation, recognized as the Trinity principle of mediation: confidentiality, neutrality, and self-determination. These are the three pillars upon which the entire edifice of mediation rests. And to speak on the subject today, it is my honor and privilege to introduce our distinguished guest speaker, Mr. Drian Speers, a name that needs no introduction in the international mediation circles. In 2019, Mr. Drian was elected president of CLA. He chaired the Commonwealth Law Conference in Nassau, Bahamas in September 2021. Even today, he continues to serve the CLA on its executive committee. Mr. Drian represents the CLA on the Commonwealth Secretariat Pro Bono Committee, which is tasked with identifying law firms to provide advice to selected member governments. In April 2021, he was appointed chair of the Commonwealth Games Federation CGF Ethics Commission. With decades of experience in civil, commercial, and cross-border mediation, he has been a leading voice in promoting ethical practices in mediation worldwide. Mr. Drian practices as a solicitor in Belfast, Northern Ireland, where he serves as the managing partner of CMG Cunningham Dickey Solicitors. His significant contributions to legal education, policy reform, and global training makes him uniquely qualified to guide us through today's session on ethics, confidentiality, neutrality, and self-determination. The importance of confidentiality, neutrality, and self-determination received international recognition through UNICETRA's Model Law on International Commercial Mediation 2018, the Singapore Convention on Mediation 2019, gave further impetus to these principles being adopted and acknowledged in the practice of mediation. In India, the Mediation Act 2023 gives legislative expression and establishes the ethical foundation on mediation, confidentiality, neutrality, and self-determination under the sections 15, 16, 17, section 22, and 23. Together, these provisions not only reflect international best practices, but also provide a strong legal backbone to ethical mediation in India. Some time ago, I came across a thought-provoking article by Senyo M. Ajibeng from Ghana titled Mediation and the Principle of Neutrality. In it, he states, for a process to be truly called mediation, it must be voluntary, informal, neutral, or non-judgmental, self-determining, future-oriented, and confidential. The absence of any of these pillars makes the mediation process incomplete. While mediation offers immense promise, it continues to face significant challenges. When we comparatively reflect on three pillars of mediation against the backdrop of India's unique social and cultural context, it becomes apparent that these qualities may not always be inherent amongst us. For instance, confidentiality and self-determination are not deeply embedded in India's traditional conflict resolution styles. There may be often a cultural discomfort with privacy, as people tend to seek validation or approval from family or community. Our speaker, Mr. A.J. Jawad, discussed the topic of impasse yesterday and explained how impactful cultural nuances can be. And he said so in the Indian context. Therefore, fostering these principles might require cultural reconditioning. Similarly, the concept of neutrality can be challenging to implement when parties perceive the mediator as an authority figure or expect them to take sides, especially given that Indian society is still often shaped by hierarchical structures. And when it comes to self determination, the basic idea of resolving one's own conflicts may not come naturally to most people. The traditional mindset of someone else knows better often prevails. While these are my personal observation, I would like to post this out as a question for later. Before I invite Mr. Brian Speers, I take the floor. Mr. Brian Speers take the floor. I wish to apprise all present here that in the next 30 minutes, we will explore the ideas and insights surrounding today's topic. Thereafter, for 20 minutes, we will interact via Q&A session. We strongly encourage participants to keep posting the questions in the chat box so that beg your pardon, no doubt or thought goes unanswered during the Q&A session. Let us make the best out of today's session. Over to you, Mr. Speers.
What a lovely and informed introduction, Mandakini. Thank you so much. That has set up the session beautifully. It's lovely to be here. In the book of Genesis in the Bible, on the seventh day, the Lord said we were supposed to rest. This is the seventh day of Nivaran, and I don't regard this particularly as a rest, because there's a little bit of preparation and thought has gone into it, but I hope that this is restful for you and that we don't have some of the technological perils that beset poor Jawad yesterday. So my name is Brian Speers. I'm a practicing lawyer in Belfast, Northern Ireland. I was the president of the Commonwealth Lawyers Association, and there are many friends here who have been at Commonwealth events and who I met on my several visits to India, to Delhi, to Goa, to Mumbai, when I was president and visited India in that capacity. It never takes much to persuade me to speak about mediation, which is a topic which greatly enthuses me, and I believe is a really valuable part of being a lawyer. The pursuit of resolution of difference and the creation of enduring and lasting settlements is surely our calling. And I do wish we were educating our incoming lawyers much more in the value of resolution rather than argument and disputation. And even though I am an enthusiast for mediation, of course, you need to have the person that you want on the day talking about the topic that you want. And to that end, I commend my old friend Santan for hustling and chivying me into action today. And I thank Nivaran, Secretary Nandini, and I greet all of you, and I greet all of my friends, some of whom I see on the screen before me. And we like to think that our societies are founded on the rule of law. And the rule of law, to some extent, encompasses morality, a sense of obligation to others, the behaviors that are needed in order to live harmoniously and perhaps justly. And those qualities find their expression in rules and codes of conduct. in the Christian faith, we have a very fundamental set of rules called the 10 Commandments. Thou shalt not kill, thou shalt not steal, thou shalt not commit adultery, honor your father and mother. And that, as an example of a faith-based code of conduct, is a stepping point for me to discuss ethics so far as mediation is concerned. Because the ethics, the behavior, and the expectations of us who aspire to be mediators are found in such things as legislation and codes of conduct. I have found that many mediators have an interest in this sort of calling to do good, to help, to resolve, and to bring about a peace building with clients or communities in dispute. And that very much inspires me and my conduct. And so the interest in, well, what are the standards that we are expected to adhere to, and how are they manifested in how we perform a mediation, certainly attracted my interest. And for the purposes of my remarks, which I will get into now, I have looked at 2 codes of conduct, the International Mediation Institute and the Code of Conduct for Mediators of the Law Council of Australia, just slightly randomly, but they are what I've looked at. Other codes are available. And I've looked at 2 statutes, legislation. And Mandakini has already mentioned the India Mediation Act. And of course, speaking to a largely Indian audience, I have looked at the provisions relating to confidentiality, neutrality, and self-determination in your legislation. But also coming from the northern part of the island of Ireland, I have looked at the Mediation Act 2017 of the Republic of Ireland. And I'll be referencing in my remarks to those 4 sources. Of course, there's a huge overlap, and what they say is, I think, pretty universally acceptable. But I think we can draw lessons from some of the differences and some of the comments that those sources make. Before considering the components of ethical conduct for mediators, might I say that the success of mediation is actually fundamentally based upon an ethically compliant mediation process and mediator. If you want to succeed as a mediator, the ethical codes of conduct, the rules of behavior are absolutely fundamental. They inform how you initially meet people. They inform how challenges and difficulties are managed. They get you through difficulties relating to confidentiality, as this discussion will unfold. The establishment of ethical conduct for the mediator, in my view, starts with the establishment of trust between you and the parties. With trust comes the relaxation of parties to share issues in confidence, some of which may not be particularly to their disadvantage, to their advantage. So with trust makes confidentiality easier. With trust also makes the reception of challenge easier. And one of the not particularly often emphasized aspects of being a mediator is the entitlement and right to put an opposing viewpoint to a party, to invite them to consider things from a different perspective, to present something that might challenge the party from their position that they have adopted, and to encourage them to be more flexible, to maybe make a concession for the greater good. And you will find that challenge, as well as confidentiality, is much enhanced if trust is established. And trust will be established right from the outset in the tone with which you communicate, the patience you have to listen to people who maybe want to say something to influence or to steer you from the initial encounter. And it also relates to one of the ethical obligations, which is to provide information about you, about your training, about qualifications, about whatever institution you might belong to or are admitted to, and about your fees and about the process. And all of that should be standard fare for mediation. And that should be something that you would all adopt as part of your ethical behavioral standards. Candor and transparency about the process and your role in it. You will explain to them from
You're on mute.
Mr. Drian, can you unmute yourself?
I think I was inadvertently muted, which is not a pleasant experience, but there we go. So I was saying, having adopted the ethical framework that builds trust, it enables the mediation to flow more straightforwardly. And it also allows you right at the outset to take permission to be a little bit challenging, and also to say that the goal of the mediation ideally is to achieve a lasting, enduring, enforceable, unambiguous resolution. And if you say that at the start, that gets you through a lot of difficulties as a mediation progresses, when a party perhaps doesn't want to share information or tries to get away with less than a candid explanation to you. And you can remind them that, well, we started this process with having a desire to create an enforceable and durable solution. And so I would expect you to be honest and straightforward with me. At the start of every mediation, I say to participants, there are two tests. One is, can you live with the outcome that we might arrive at? And is that outcome better than the alternative? And those are two very valuable tests that I share with you. And all of those elements that I've just said flow through into what we will look at. The first element of mediation, ethical mediation, starts with preparation that builds trust, allows disclosure and concession and consideration of alternative viewpoints in the safety of a confidential process conducted empathetically and effectively. So if that is my goal of mediation, how am I helped by the ethical framework? Neutrality is very key. It is recognized in the Mediation Act of Ireland in section 8.2, where it talks about the mediator making such inquiry as is reasonable to determine whether she or he may have any actual or potential conflict of interest. In the India Act, section 10 says the person appointed as the mediator shall, prior to the conduct of the mediation, disclose in writing to the parties any circumstance or potential circumstance, personal, professional, financial, or otherwise, that may constitute a conflict of interest or may give rise to doubts as to his independence or impartiality as a mediator. So it seems to be appropriate for it to be included in statutes in India and Ireland. In the Australian Code, it says, again, same thought, but different and pleasingly different wording, a mediator may only mediate in those matters where the mediator can remain impartial and even-handed. And in the IMI code, it speaks of mediators acting without any conflict of interest, and it recites the conflicts as being financial, personal, or other, present or past. So this question of impartiality, neutrality, is really very important, because what it enables you to do is to build that trust that is all important, and you must continue from the initial engagement through to the conclusion of what you hope is an enforceable and comprehensive agreement, but after, to remain impartial, to not be seen to take sides, to not be unconsciously biased towards one party or another. And in that regard, there are some behaviors that you need to watch out for. So you might well know one of the representatives to the party, to one party, and not the other. Well, that does not amount to a conflict of interest, but you need to be careful not to be too playful when you greet them and say, Arun, old bean, nice to see you. And then that gives the impression that, oh, well, he's already friendly with one of the party's representatives. So you must remain impartial. You need to be careful not to be seen to be having too good a time in one room and laughing, and great gales of laughter sweep through from their room, and the other room is wondering what on earth is going on. You need to be careful of taking a cup of chai or coffee with one room and not the other. And I would say that really your impartiality and neutrality has to reflect all of that. You are there formally, you're dealing with parties in a reasonably formal way. You might spend more time with one rather than another. You might speak to one in a different way compared to another, depending on their personality. But you do need to remain very steadfastly impartial. So the codes seem to emphasize that. And I just put out a little question. I was asked to do a mediation which involved a dispute about the condition in which a large commercial building had been left by the outgoing tenant. And that gave rise to what's called a dilapidations claim. And the parties included the tenant, who maybe 8 or 9 years ago I had done some work for, a previous client. And the other party, in fact, was one of our leading families of an Indian family in Northern Ireland who's built up a great hotel network. And they were the landlords of the building. The former client, who I hadn't seen or spoken to in, let's say, 8 years, was the other party. Both were content that I disclosed that I had previously acted for the tenant. Should I have proceeded with the mediation? Is that going to give rise to a perception of friendship or favoritism to the former client, or quite the reverse? Is that going to mean that because the former client isn't my client anymore, am I less favorable to them, and I'm getting my own back for dropping me as their solicitor? So just as a little reaction, you might put, would you have acted in those circumstances? And that might be a practical illustration of the conflict of interest and the need to remain and be seen to remain neutral and in a non-conflict position. Now, of course, you might be keen to get the fee for being the mediator, and you might be keen to get the mediation. But there you are. It's a small issue about neutrality. Can I say something about confidentiality quickly and then self-determination? So the India Act does indeed have confidentiality. Clause 15 talks about the mediator being guided by the principles of objectivity and to protect the confidentiality and self-determination of the parties. I like, however, the Australian take on confidentiality, which says simply that confidentiality, subject to the requirements of law, a mediator must maintain the confidentiality. And in the comment section, it then says, as the parties' expectations regarding confidentiality are important, the mediator should discuss those expectations with the parties. So although there are exceptions by the overriding good of society where confidentiality can be breached because there's a crime to be committed, there's harm to a person, there's some overriding justification for breaching what is otherwise a very firm obligation, there are some circumstances where the parties themselves can't keep the outcome of the mediation or even the fact of the mediation confidential. And although we frequently say the mediator shouldn't disclose that there even is a mediation, should definitely not disclose what a party in a private meeting tells them in that private meeting, should not disclose ever what was the result of the mediation, actually, I think Australia have hit on something quite helpful, which is that each party might have a different requirement for mediation. Some public bodies, government agencies, have a duty of candor. They can't just wrap something up in confidence. Some mediations themselves involve matters very much in the public eye. And I was struck by comments made in a session at the Borneo Rainforest Law Conference that the CLA organised a little while ago by an Australian mediator called Mary Walker, who incidentally has been on the committee for the Australia Law Council Code of Conduct for years and has been very instrumental in shaping that. And she described environmental mediation where there might be a community affected by a pollution event. There might be public representatives of that community. There might be state agencies there to enforce compliance with environmental law. There will be the polluter, and all of these people need to be managed in what might be called an environmental mediation. The confidentiality of what they say at open public meetings, of course, is not confidential. How it is reported and what is said in the press might need to be discussed with the parties in advance. So confidentiality, I think, is not absolute. It can be specific to the nature of the dispute and the parties, but what is absolute is that the mediator cannot go talking about the mediation casually or carelessly, and the mediator has to assure the parties that what they tell you in the mediation private meeting will remain confident between you and me, and I will only share with the other side what you would like me to share and what is helpful to share. And that reassurance, I think, is helpful to the process. So confidentiality, you can sometimes be asked by the other side after a session, and you go and meet the room that's been waiting to see you. Well, what did the other side say? What do they want? What did they say to, the proposal that I authorize you to take to them? And you might not be ready to say that. In fact, your response should be, look, I'm here to help. I'm keeping what you say to me confidential. You'll understand that I have to keep what they say confidential. And really what's important to me is what you are willing to do in this room and then I will be able to identify if there's an overlap or a shared possibility. So you can be put under pressure to disclose what you have found out from a confidential private session, and you need to resist that. A few words on self-determination. So in Ireland, there's some very interesting words in their statute. Clause 11.3. It says that ordinarily an agreement reached in mediation will be enforceable unless a party, and this is the language, has been overborne or unduly influenced by any other party in reaching the settlement agreement, because the agreement is their own agreement from self-determination. And in India, the Act says that it's the responsibility of the parties to take decision regarding their claims. In 16.1 and in 16.2, the parties shall be informed expressly by the mediator that he only facilitates arriving at a decision and he shall not impose any settlement. And that's really underscoring the fact that the mediator assists and the parties decide. So the self-determination is very intriguing. The IMI code uses some, again, helpful language that the mediator shall conduct the mediation based on party self-determination, which means that the parties with capacity voluntarily make informed decisions without coercion. So voluntary decision-making is an exercise of choice, not dominated by feelings of distress or helplessness resulting from pressures exercised by others, including mediation participants and/or the mediator. So we have to be very careful as mediators not to press, not to stress the parties, not to force them or pressurize them in any way that interferes with their ultimate right of party self-determination. And just to complete what the Australian code says, mediation is a process where an impartial person facilitates the resolution of a dispute by promoting uncoerced agreement by the parties to the dispute. Now, this gives rise to all sorts of intriguing issues, because in a mediation, you've built trust, you've gained confidence, you've heard things, you might be tempted to steer the parties in the direction that could have an overlap of their interests. But how do you do that without pressurizing, without concealing information, which you shouldn't, because your role is to be candid? And how do you make sure that you are not placing pressure on a party to do something which they really will regret? And I come back to my test. Is this agreement something that you can live with? And I come back to the obligation of training, because another, and this is just my final winding up type remarks before our discussion, another obligation in codes of conduct is that the mediator must be competent. And competence does not mean that you've just been around for a long time. Competence does not mean that you have been a judge. Competence means that you have undertaken mediation training and that you have got the skills required of a mediator, a different discipline, a different skill set from simply being an experienced lawyer. That competence should let you understand that you are not to influence, coerce, pressurize, arm twist, or any of the other expressions and end up with a party not happy and in fact regretting that they might have agreed to something. And can they live with it? They need to go back to their community, their fellow directors, their business partners, their family, and say, I went to the mediation I've agreed this. And then there's a chorus of why did you agree that, or how did you agree that? And that's a very problematic outcome for mediation if a party feels regretful, and a mediator needs to be careful that they are not, and nothing else in the process is contributing to a party feeling unhappy. Now, that is not to say that unhappiness with the outcome is a bad thing. In fact, in nearly every mediation I have done, I lightheartedly say of a tale I was told by a lawyer from England who came to Belfast for a mediation. And he said, "Perfect job, Brian. Nobody is happy." And I think what that meant was that there was compromise. People were stretched a little bit. They reached an agreement. They weren't unhappy with the agreement, but the sense was that they were made to work a little bit harder than they might. So the other codes, the codes of conduct refer to competence, the absolute obligation of training, the explanation in a candid way of process, fees. I believe that fees should not be linked to outcome. You shouldn't be, as a mediator, motivated by a sense of the more time I spend or the more I save for one party, the better my fee. You should just be doing the job, neutral, impartial, professional, trained. And by adopting ethical principles and adhering to legislation and codes of conduct with skills and training, the mediator will have built trust, provides a fair process which is understood, and will manage the process with competence, will act impartially, avoiding any conflicts, will respect confidentiality and to the standard agreed by the parties to the mediation and understanding parties' requirements, and can take permission early to challenge, to ask for explanations as to why people have maintained a position which might be seen to be stubborn or unyielding, but never cross the line to pressurize or squeeze to get an agreement. And I come back to, can you live with this solution, and is it better than the alternative? And so I think that maybe Mandakini is enough from me, and there are very many worthy colleagues here who can disagree with me or contribute to comment, which I, because I've been speaking, have not been able to follow particularly closely, but I'm all yours. Thank you.
Thanks to you, Mr. Brian, for this was a very, very informative presentation. Thank you. So the key takeaway from today's lecture is while some qualities are inherent, others can also be codified and described. This is where codes of conduct become especially valuable. Such codes set out the essential elements that must be present, and confidentiality, impartiality, and self-determination are just three of the standards required in many of these codes. Mr. Brian also highlighted how a mediator fundamentally must have the personal integrity and essential skills to build trust with the parties, as this trust is critical to achieve a successful mediation. Thank you once again, sir. We truly appreciate the knowledge and the experience that you have shared with us today. Now we will move on to our Q&A session. And I already see many questions here in the chat box. So the first question that has come from Mr. Arjun Krishna is, how can we ensure confidentiality in AI-driven mediation sessions? What is the future of AI-driven mediation?
Yes, I saw that question, Mandakini, and it is a great question. The platforms that are used have improved in terms of their confidentiality, in that who can join. But what, of course, you don't see, well, there's many people attending today who we don't see other than their screen, but those who we do see, we can't see if there's others present, if there's coaches present, or if there's people waving frantically behind a table across the room that's not on camera. And that can be difficult for online mediations, simply because you're not aware of who's in the room. So normally on the Zoom mediations that I have done, you are doing careful preparation in advance to let people understand that it's important to the integrity of the process that you know who's going to be present. There's no objection to people being present who the party with the dispute wants to have. I mean, really, that's not the issue, although it can be the issue if the non-party is over vociferous and they have no skin in the game, or they have no stake in the outcome, and yet they're not inhibited by contributing their opinion. You often get that, I'm afraid, with experts and often with legal representatives. It's not their case. The party wants to resolve it, but the lawyer or the expert witness or their uncle doesn't let them. And in that case, you really do have to speak to the party whose dispute it is alone as much as you can. But you can't do that easily, or you can't see that easily in a Zoom. So it is suboptimal, but it is at least a way of progressing. And a lot of the issues that are being placed in the chat and concerns are capable of being imagined. In some cases have occurred, but are not absolutely the overwhelming day-to-day experience. People talk about mediators being sued and breach of conduct actions against mediators. They are very few and far between, and proper training and proper preparation really ought to deal with most of the reasonable issues about whether there's others listening in or whether there's others that can listen in. That's just my remark on that question.
Thank you so much. So the next question is by Mr. Manoj Mathur, another Zoom-related question. He says that my question is about privacy in the face of technology such as Zoom. We are having this session on Zoom, whose privacy policy allows it to collect, use, and share personal data, including meeting contents, audio, video, chat, etc. Most, if not in such platform that are used for mediation follows such privacy practices without an opt-out feature. Request your views on confidentiality vis-a-vis the privacy policies of platforms such as Zoom.
There will be others here, Mandakini, who know a lot more about the privacy policy of Zoom than I do. My answer is that if you are having a mediation on Zoom, it is because the parties have agreed to have a mediation on Zoom, that you should have a form of agreement that sets out ground rules. Mediators love ground rules for a mediation, and that's just another one of the ground rules. Are you content, even though we cannot control absolutely the privacy of Zoom or any other platform, are you content to have a mediation? And in my experience, most will be content. They factor in the risks because of their ordinary experience. A thing that is peculiar is the use of artificial intelligence, which seems to follow you around in order to make meeting notes of meetings that you attend. And they make very good meeting notes, but you may have a meeting that you don't want to go somewhere into artificial intelligence land to make meeting notes. So one ground rule would be to say that you will disable any artificial intelligence function that might follow you into a Zoom discussion. But other than that, I'm very happy to learn from the experience of others regarding that. But I would say preparation and ground rules and agreement of the parties will take you most of the way to everybody being comfortable.
Thank you so much. Next question is posted by Ms. Sangeeta. If a proposed settlement appears legal but morally questionable, like unfair to children or dependents? Should the mediator intervene or remain passive?
Well, this is one of your classic university student mediation dilemmas that some mediators love to think up. They rarely occur, but they do pose all sorts of dilemma handling. Fortunately, the codes of conduct and the statutes that we've looked at do provide answers, because all say that the mediation is confidential other than in the exceptional cases, such as there's a disclosure of a crime, there is harm to a child, there is something that is against public policy. And I did reflect on this, anticipating a question such as that, about some environmental cases, for example, where you may have a pollution. It may indeed be a criminal act, and yet the polluter and those affected are trying to mediate a settlement. And, can you do that in confidence and avoid a criminal sanction? I think that we're in this very subtle area of difference between public policy being supportive of confidentiality in mediation, but that has limits. And if those limits are exceeded, then the mediator should say, I cannot take part anymore, or the agreement such as you are proposing is one that I cannot preside over and, if you like, sanction, and you need to withdraw. Where the line is very much depends on your personal integrity, which code of conduct might apply, which statute might apply. But if I can find my note just on confidentiality quickly here, the Irish Act does say that everything is confidential, except where it is overborne by the sort of coercion that we spoke about, or is not compliant with the law. And the Australian position, I think, talks about what is the confidentiality expected and about what the law is. And so you do have limits. The codes of conduct allow you to know where the limit might be. But where that limit is slightly imprecise. And it is one of these sort of dilemma gray areas. But I think that if you are true to yourself and your own integrity, as a mediator, you would not want to preside over something that conceals a crime or reveals child harm or anything of that sort.
Thank you so much. Another question from Ms. Snigdha Bhattacharjee. In situations like, for example, where a mediator becomes aware of information that could significantly impact one party's decision-making, such as undisclosed financial assets, etc., how should the mediator balance the ethical obligation to maintain confidentiality with duty to ensure each party's right to self-determination?
A brilliant but a hard question, Snigdha. And the answer to it, I think, is going to be this. At the very start of my remarks, I said how important it was to establish trust, and that trust is established by adhering to ethical guidelines, but also by making it clear to the parties what the process is, how they can expect an entitlement to confidentiality, but the confidentiality has limits. But also, I'm sure that I said that there would be a general agreement that our goal today is to see, can we solve this problem? And the problem will be solved by being candid and open, and it will be permanently solved if there is no afterthought arising because one party has concealed information or has not made the other aware of some legislative provision that impacts, or that the smart lawyers are outgunning the average or the absence of lawyer from one of the parties. And so the mediator, I think, needs again to set that within the ground rules. Our goal is, we've agreed to a candor. We've said at the outset that our mission is to see, can we have an enduring and permanent resolution? And that enduring and permanent resolution is not achieved by you keeping, some information that might be relevant, which, if it comes out, will result in potentially the upsetting of the agreement that has been made. And so I would say that I would remind parties that there is a need to create the enduring agreement, and by concealing information, which they say to you, don't tell the other side, but I think you would have to challenge them a little bit and say, how will this impact, or how do you think this would impact on the endurance and permanence and efficacy of the settlement you are proposing if this comes out later? The IMI code talks about making voluntarily informed decisions, and they go on to describe an informed decision as an informed decision is made based on information relevant for making that decision. A mediator cannot ensure that parties make decisions that are based on complete information, and the mediator must assist parties to consider whether they have sufficient knowledge that a reasonable decision maker in the circumstances would have considered relevant for that decision. So you're getting little hints of how the mediator can, by adhering ethically to confidentiality, by setting ground rules, by reminding parties that the mission is to have a permanent and durable outcome, that might overcome a reluctance of one party to make a more complete disclosure.
Thank you very much. Next question is by Shireen Khajuria here. In Ireland, has the challenge on grounds of undue influence to unsettle a mediated settlement been an unruly horse, or the challenges are limited?
Well, I'm not interested in things equestrian, but I can absolutely assure you that there are unruly horses in Ireland. So the question is, this is a different jurisdiction to me in Northern Ireland, but I am not aware of any challenge. This issue of challenging mediation agreements is theoretically possible to contemplate. But if you adhere to these guidelines, codes of conduct, ethical framework and training, you're really never going to be in that situation. You're not going to be unduly influencing any party, because you have been trained not to unduly influence. And the parties end up with their agreement written up, they're signing it, they're consenting to it, you're satisfying them that it's better than the alternative and it's one that they can live with. And it's very, very rare for mediators to be challenged after the event. Now, if you can just hold that frame, Shireen, and remember it for tomorrow's session, where we have my good friend, Justice Vashisht Kokharam from Trinidad. He presided over cases in Trinidad which did arise from a challenge to the mediator. And we might surprise Vashisht by talking about challenges to the mediator and what then does that do to the confidentiality of the process, and how do you get evidence about the unruly behavior of the mediator during the mediation. So all of these are really interesting conceptual issues. I venture to suggest that they arise very rarely in practice, but they're great questions and they help me draw out the fact that proper training, proper preparation, and a proper awareness of your ethical role will steer you away from the back kicking of the unruly horse.
Thank you very much. Next question by Adanhair Jones. What guardrails do you suggest for keeping the mediator from overreaching based on biases and cultural differences, communication style?
Brilliant, Adhinder. Thank you for that question. And the Commonwealth is a very interesting organization. And as I traveled to many of the Commonwealth countries during my presidency, I was alive on the surface to the fact that there are indeed cultural differences. Mandakini, I would love you to expand on the brilliant remarks you made at your opening about how culturally some people do not like to disagree with an authoritarian person. The mediator, of course, might be seen in that role. If the mediator is a judge, even worse. No party is really easily going to be saying, well, I want to just disagree and leave the mediation in tatters because it's disrespectful to my lord. So that would be less so in my jurisdiction, where we would relish the prospect of being disrespectful to a retired judge in a mediation, or at least we would be not fearful of disagreeing and speaking our mind candidly and frankly, but respectfully. There are also issues to do with the cultural affirmation of agreements, that it's not just that, we're all from a village, but we are all from a community, a family, a connection. And very often that connection is important to support and validate the agreement that you make. So I would always ask, who do you want to be at the mediation with you? Do you need someone to support, while at the same time saying your supporter is not you? What you agree with is not what the supporter has to agree to. But I do recognize that, and I also recognize that there are some gender-related cultural issues. And there are, a bloke like me turning up in a suit and tie might not be the best to deal with some disputes. And indeed, some disputes involving perhaps civic society issues and relationships between community groups. I, of course, wouldn't turn up in my suit and tie. I would want to appear visually and in every other way empathetic and meeting them at their level. So yes, I was invited last November to speak at a mediation conference in Port Moresby, Papua New Guinea, by the Deputy Chief Justice, who's a great friend of the CLA, Justice Kandakazi Ambeng. And Ambeng is a great fan of mediation. He should be part of this next year. I just dropped that in. And he showed slides of a mediation that he did with some tribal issues involving indigenous people and their forestry rights, which were being decimated by logging companies. And the mediation took place, and the tribal elders came, and there was some sort of a tent erected in which the mediation occurred. And one of the ground rules was that all the tribal chiefs had to leave their spears at the door. And there was this collection of armaments and instruments left behind, which was an interesting cultural sort of dimension to a mediation. So I do not pretend to say that in India and in all parts of India there will be cultural variations, and in the Caribbean and in Nigeria and Ghana there of course will be those issues, and trained mediators should be alive to them and be respectful of them. And I think mediators should be self-aware to the extent of knowing whether they have competence to enter a culturally sensitive mediation when they have no experience or cultural training or alignment. And that is, of course, one of the codes of conduct requirements, that you are competent to do the mediation. Not that you know about concrete, or not that you know about medical treatments that have gone wrong, but that you are competent to do the mediation. And that, in my view, would include cultural competence. Maybe Mandakini, you want to expand on that, because what you said was fantastic at the beginning.
Thank you so much. Some other time we'll keep that. Today is your day.
Oh, okay.
We are running out of time, and I still see a lot of questions posted, but I'm afraid we are out of time. And I would like to thank you for graciously addressing so many questions with so much of patience and precision. We truly appreciate the clarity and depth you brought to each response. I would also like to thank the participants here for the active presence and engagement throughout the session. Here, I would like to share a few details of tomorrow, that is day 8's session. The topic for tomorrow is mediation advocacy, and the speaker is Justice Vashisht Kokaram, Honorable Judge, Court of Appeal, Supreme Court of Trinidad and Tobago. The session will be hosted by Ms. Smita Inna Shukla. And last but not the least, I would like to acknowledge the highly efficient technical team of Nivaran, Rahul, Rohit, and Keshav. Thank you for ensuring everything runs smoothly and effortlessly. Once again, thank you, everybody, and goodbye.
If I can nip in and say thank you, Rahul, behind the scenes, if he's there.